Meanwhile, a Supreme Court showdown is intensifying over President Trump's tax returns. Remember this? The justices listened yesterday to arguments about whether the president can keep his financial records secret. Two House committees and New York prosecutors are demanding he follow precedent and make the information public, like past U.S. leaders. However, President Trump's lawyers argue he is immune from criminal prosecution while he is in office. For more on this, let's bring in Ilya Shapiro to talk us through what we know. So, Ilya, take us through this case. I saw Jan Crawford's piece this morning on CBS this morning, and in it you could hear the various justices sort of making their points, I guess, if you want to call them that, trying to walk the line between presidential privilege and authority and the constitutional power that Congress has in seeing the president's financial information should they subpoena it.
Well, it's not so much walking the line, but drawing the line. That's what really came out of these two cases that were argued yesterday. If you allow some sort of subpoena power by Congress, and here three different House committees, for what's supposed to be a legislative purpose, then where do you draw that line? In theory, a clever lawyer can come up with any demand for personal private health records or other documents from presidential family members, because that all could go to some legislative purpose for policy in that area. And the justices were troubled about that. Similarly, with the Manhattan DA, it's a different sort of issue because here it's a state demanding an investigation and grand jury subpoenas from the federal executive, kind of a separation of powers thing with the House. Here it's a federalism thing. But anyway, if you just go on a fishing expedition, kind of a limitless warrant, perhaps the word harassment came up in both cases. What if you just have different states and different House committees of the opposite party harassing the president? On the other hand, is there absolute immunity? Probably not. So I think what we're going to see, the most likely situation, is kind of a very narrow opinion by Chief Justice Roberts saying, yes, in theory you have the subpoena power, but here is the strict standard, sending it back to the lower courts for further development. And hopefully this all goes away because either the president doesn't get reelected or he gets reelected and he's popular, and who knows what the court would do with it in the future.
Ilya, can we just sort of drill down a little bit more on one of the arguments coming from the president's lawyers, which is that he can't be prosecuted. He's a sitting president. Can you sort of explain what the argument is and how it's being received by the justices thus far?
The idea is the president obviously has a lot of things to do in his job. If he's distracted by these constant legal proceedings, that's a real burden on the presidency, on the office of the president. Now, this is not about his personal immunity. If he leaves the presidency, you can restart those cases. Nobody is disputing that. But the argument is that this takes away too much from presidential discretion and focus on the job. Of course, there is a Supreme Court case, Clinton versus Jones, that said that President Clinton could be subject to continued civil litigation. This is why his deposition in the Paula Jones case came out, where he perjured himself. That led to the whole Monica Lewinsky affair. So that's a different sort of situation. That's not a subpoena from either a House committee or a DA. This is kind of already litigation that he is being sued. But that's pretty strong evidence that the immunity, whatever it is not total.
Yeah, it's an interesting point, Ilya. And I guess, speaking as somebody who's not a lawyer, that when we say the presidency, the Supreme Court obviously is setting precedent, or they do when they ultimately make their rulings. So, in other words, the president being busy running the country, can't be distracted by something like this, would apply to all presidents in the future.
Absolutely. And the government, not President Trump's personal lawyers, but the Justice Department argued not for total immunity, but for kind of a heightened standard, a special needs requirement, a specific showing by the House committee that's more detailed than what they have now. So probably that's where the court is going to go. And then, lower courts will have to figure out whether these demands, which are, by the way, pretty much the same. The subpoena is worded pretty much the same from these House committees as from the New York DA. They'll have to evaluate whether that's the sufficient specificity, or is it a fishing expedition or some sort of harassment campaign.
So, Ilya, I want to ask you about another really interesting case, particularly interesting because we are in an election year. It has to do with the Electoral College. And sort of the main question being debated is whether or not electors have to vote for the candidate which was the most popular in that state, or whether they can vote for whoever they want when they cast their ballot. Take us through this case here. Maybe as briefly as you can, just how did we get to the Supreme Court level, and what's at the center of this case?
Yeah, this case or two cases is still being argued right now as we speak. I'll go back to that once we're done speaking here. But this came out of the 2016 election where a number of what are called faithless electors declined to vote for either Hillary Clinton or Donald Trump. They were hoping, they had various reasons. But anyway, 7 of them did count for other people. Colin Powell got 3 electoral votes in Washington State, for example. Ron Paul got an electoral vote in Texas. John Kasich got it. Anyway, 7 of these votes counted for other people. And historically, there have been faithless electors in other elections. Now, the question is, can a state punish someone, fine them, or can they remove them if they are voting improperly? And the Constitution is fairly silent. That's why this has gotten to the Supreme Court. States generally control the electoral process, but at the same time, does this not violate an elector's First Amendment rights or other rules for the federal government structuring how the vote for president runs? Are states really in control? It's a fascinating case that doesn't break down on liberal, conservative, or other kind of conventional lines.
So what implications, Ilya, could this have on the upcoming presidential election?
Well, if it's a close election in terms of the Electoral College, within a few votes, then these faithless electors really come into play, depending on how many of them there would be. If nobody gains a majority in the Electoral College, then the House of Representatives is going to decide who the president is. Or for that matter, if they switch between the major party candidates, you could have what should be the Electoral College winner become the loser. And that's why it's good that we're hashing this out now rather than in the midst of the election campaign or the election aftermath.
Indeed. Ilya Shapiro, always good to talk to you, breaking it down for us, what is happening there in SCOTUS. We appreciate it as always.
It's been a fascinating 2 weeks of telephonic arguments. I don't know what I'm going to do with my
It really has. I was going to say, I mean, it's sort of like, I guess, you got to keep your phone on mute, Ilya, as we found out last week when somebody flushed a toilet. And yeah, it's like you grab the popcorn and just in a notepad and take some notes.
Or the live tweet machine. This is the thing that the justices really won't like. Not necessarily about the structure. I actually like the structure of argument going in order so they're not jumping on top of each other. But the live audio stream, I'm sure they won't like to see kind of the live tweeting, even if it's nothing inappropriate, but just having that instant reaction. I'm sure the justices won't want to repeat that in normal circumstances.
That's true. That's true. And I should just point out for our viewers, Ilya, because you just mentioned Twitter, that when I made the joke about a flushing toilet, it was not you. Somebody last week, I just see how Twitter operates, and all of a sudden it's like, Vlad just accused Ilya Shapiro of flushing a toilet during the Supreme Court arguments, and that's not what happened, folks.
No, in fact, those of us who listen along aren't. There's no question about mute buttons or not. Those of us just listening, just listen. It's only for the lawyers arguing and the justices themselves. Who are subject to that.
Good to know. Ilya, thank you very much.